Good morning.
Good morning.
So I got your motion relative to child support. Um, and the motion claims that his child turned 18 and graduated from high school. So I contacted them, the front of the court anyway, so they could confirm that because generally that's all you need. All you need to do is send a copy of could be a diploma, could be the high school transcripts. Once they get proof of that, they'll stop the child support. Okay. The problem is um, uh, they can't, apparently, Mr. Brown does not have access to that information. So let me first turn to Mr. Brown and then I'll hear from Miss Dennis. Is that correct, Mr. Brown? You can't figure out if this child did in fact graduate?
I hold on. What I just push this start video thing?
Go ahead.
I can't get the camera to come on.
You
But
don't have to. I can hear you just fine.
okay. They've been in Detroit for like 6 years or something. So but I have the I have like Facebook stuff. I got pictures of her graduating. She she graduated in May of last year.
Hang on a second. All right. Well, this should be easy to figure out. Miss Dennis,
Yes,
do you
yes.
do you know what we're talking about
Yeah.
here?
Let me just start off by saying is yes, it's going on 7 years that I've been here in Detroit. He haven't talked to my daughter since she was 12. She had life monumental moments, graduating prom. She in hair school. She graduate November of this year. So he never reached out to say congratulations, never nothing on nothing. But it's temporary for him. It's a lifetime for me. She's 18 and she transitioning. She paid for cosmetology school out her pocket, trying to make ends meet. So that little bit do help. And as far as the child support goes, he ready to put an end to it because he don't talk to her. He don't talk to me. I done reached out, text him and everything, and it's nothing. But he could go down there to the court and say that she done and this and that. He got pictures when he don't even talk to her. My baby going through what she go through behind him. And I would like for the child support to continue on until her 19 to the end of her 19th year. It stopped in September. The court told me it stopped in September of this year. But I would like it to go to her 19th year because I still have expenses with her. It don't stop for me, but it stopped for him. And he wrote that motion. She done with school, she done with that. He wanna wash his hands of her completely. And I feel like that's so unfair that I didn't lay down by myself. I laid down with him and not once he contributed to anything. In 3 years, I came down here and I lowered his child support to $35.
Yeah,
35.
right.
If you see it in records, you look in your records, see in the record, me and him came down to the courthouse. I lowered the child support down to $35 only on the strength of he get her on weekends, get her on holidays, get her on summer vacation. He couldn't do that. I had to wait 3 years to raise the child support back up because he still refused to participate. So
Okay. All right. I got the picture. I want to tell you both something. There's a lot of things I can do sitting here today, but there's two things I cannot do, and I hope the parties understand.
Before we even hit play, buckle up. This hearing isn't just about child support, it's about control, closure, and emotional warfare. One parent's fighting for continuation, the other's fighting for freedom. The question is, who's really doing it for the child, and who's doing it for themselves?
I can't make somebody a good father or mother. I can't do that. I wish I could. Because if I did, I would have probably very few of these cases. Um, but I can't do that. And I wish I could, because I think your daughter deserves better. She deserves something. The second thing is I cannot violate the law. Okay, I have to follow the law. And the law in this case says that someone can collect child support until the child is 18 or graduates from high school, whichever occurs later. Now, she has done that, okay, by everybody's admission. So the law says that I have to terminate his child support, but I am doing it effective the date he motioned me, which is the first charge date. He motioned this on January 9. So the first charge date, somewhat close to that, is January 1. So I'm going to grant the motion to terminate child support effective January 1, 2025. And what you need to do, Mr. Brown, is you need to come to the courthouse on the 5th floor Legal Assistance Center and prepare an order for me to sign, which you need to send to Miss Dennis. And the order says that your child support obligation for this child terminated on January 1 of 2025. And I will sign that. And I wish everybody the best. I wish your daughter the best.
Say one thing.
Sir, yes, sir. Can I say something too? I'll let her go first.
Stop.
Go ahead, ma'am.
Right. Go ahead, real quick.
Hey, so the courts told me that the child support is ordered all the way until September of this year. So you throwing that order out?
There's no order saying that.
That's what the courts told me. That I called it.
I should tell you this, Miss Dennis, that unless you have paid the person to give you advice, you shouldn't rely on it. Okay?
Mm-hmm.
Because what I'm thinking is they may have told you what happens if she's still in high school, maybe not. Child support goes until someone
Here's where the first crack shows documentation. Courts don't run on feelings, they run on proof. Without official records, Facebook pictures and memories mean nothing legally. You can feel like a parent, but in court, you have to prove like one.
Or turns 18, whichever is later. I've had a lot of 18-year-olds still getting child support because they haven't graduated high school yet. I've had a lot of 19-year-olds who get child support because they haven't graduated high school. But this child has graduated high school and is over 18, and the law says I have to stop it, but on the effective date of a motion to stop it. This motion was filed January 9. So the closest charge date I have is January 1. And that's as far as I can stop it. Like I said, all I can do is follow the law. And that's what I have to do. Now, Mr. Brown, what can I do for you?
Well, I got two questions. You said go over there to the 5th floor and get a what, man, sir?
Mr. Brown, you're getting yourself into more difficulties. You really need an attorney to help you because, so I need you to go, you know where the courthouse is?
Yes.
On the 5th floor.
Right.
It's called the Legal Assistance Center.
Right.
I need you to go there and they will help you prepare an order terminating your child support effective January 1, 2025, and that all arrearages are preserved, period. That's all you got to do. And then they will prepare the order. You got to send a copy to Miss Dennis at her.
And here comes the emotional surge, pure pain, unfiltered. You can almost feel years of resentment flooding out. But watch closely when emotion takes over logic. Judges start tuning out. It's not cruelty. It's courtroom survival. Passion doesn't win verdicts. Paperwork does. Next is the pivot. The judge is about to draw the line between empathy and law. Every strong judge knows you can feel sympathy, but you can't rule on it. Watch how he maintains total control while dismantling the chaos with surgical and there it is, the gavel of finality. The law doesn't bend for pain. It calculates by criteria. Once the child graduates and turns 18, support ends. It's clean, cold, and final. The father didn't win because he was right emotionally, he won because he was right legally. Notice how the judge never raises his voice. That's authority through restraint. He's not battling her, he's anchoring to the law. And that's the real dominance here. The moment you master your emotions in chaos, you stop reacting and start ruling.